Since this episode was recorded, there's been a major update. On July 2nd, 2025, Bryan Kohberger pled guilty to 4 counts of first-degree murder and 1 count of felony burglary, avoiding the death penalty. And just 3 weeks later, on July 23rd, he was sentenced to 4 consecutive life sentences without parole and an additional 10 years for burglary. The court also imposed a $270,000 restitution and civil penalties. Welcome back to Mystery and Murder, the podcast where, as you know, we unravel the most captivating and infamous true crime cases. And the goal is to go beyond the headlines and examine the minds of the perpetrators, why they do what they do, and how their actions can help us better understand the human psyche. We also look at the minds of the victims and how it affects them, how it affects their families. We just look at the psychological aspects of these terrible episodes and incidences and how they impact everybody involved, because it has a ripple effect, doesn't it? You know that. Sometimes just going through these and studying them has a ripple effect. It touches so many lives, including yours. And so I want to give you the tools to use this and analyze it. Now, during our last episodes, we dove into the harrowing case of the Moscow, Idaho murders, the shocking and brutal quadruple homicide that claimed the lives of 4 college students. The suspect that emerged, a 28-year-old criminology PhD student named Bryan Kohberger, who went on to be arrested on December 30th, 2022 in connection with the murders. This alleged killer awaits trial and the world is watching. And I say alleged killer because, listen, until he is tried and is either convicted or not, he still cannot be considered guilty. You may feel strongly that this is the person, but this is the United States of America and everyone is entitled to due process. Now, let's break down the serious charges that this individual faces. He's looking at 4 charges of first-degree murder for the deaths of Madison Mogen, Xana Kernodle, Ethan Chapin, and Kaylee Gonsalves. In Idaho, a conviction for this charge carries penalties ranging from life imprisonment with parole eligibility and life imprisonment without the possibility of parole, and he could be subject to the death penalty. Kohberger is also charged with 1 count of felony burglary, the allegation being that he unlawfully entered the victim's home with the intent to commit murder. If he's convicted of these charges, prosecutors, led by Deputy Latah County Prosecutor Ashley Jennings, have indicated that they will pursue the death penalty. On May 22nd of 2023, Bryan Kohberger was arraigned in court after a grand jury indicted him on these charges. Now, quite unusually, Kohberger stood silently. When asked to give a response, he stood silent. He wouldn't enter a plea. And once his attorney informed the court of his decision to remain silent, the judge, as is standard procedure, was then prompted to enter not guilty pleas on his behalf to all of the charges. Now, a lot of legal experts have weighed in on this and suggest that his choice to stand silent could be just a deliberate tactic to get attention. Maybe it's influenced by his criminology background, because as we mentioned in the last episode, he was studying criminology. I'm not sure what his exact motive was, but clearly, in my view, it was manipulative. Maybe he's trying to influence the proceedings, or it's just attention getting, who knows. It did get attention. We're talking about it right now. Now, the trial was originally scheduled to begin in October 2023, and the trial has faced significant delays. The state of Idaho versus Bryan C. Kohberger is set to start now on August 11th, 2025, with proceedings expected to last through November. So they're expecting an 8-week trial. You would expect at least that if it's going to be hotly contested, because there are 4 different murders and 5 charges here, because you've got the breaking and entering charge. All these delays stem from a variety of factors. First, he waived his right to a speedy trial. Look, under Idaho law, defendants are entitled to a trial within 6 months of arraignment unless they waive this right. Now, that's typical in almost every jurisdiction. You can't just take somebody and hold them forever. If you arrest them, they're entitled to a fairly expeditious trial, which is why I say prosecutors have to have their ducks in a row before they make an arrest, because once they do, they've got to get to trial pretty quick. They can't start building their case then. They have to have it done ahead of time. By waiving his right to a speedy trial, his defense team has gained additional time to prepare. So they've pushed the start date. They also filed for a change of venue. This is often requested, seldom granted. But in this case, the court granted the defense team's request for a change of venue on the grounds that it would be too challenging to find an impartial jury in Latah County. The murders occurred there. Obviously, they were very high profile. Everybody was concerned. Everybody was worried. They were afraid they had this lunatic running around stabbing people. The trial has now been moved to Ada County in Boise, Idaho, about 300 miles away. This required transferring Kohberger, reassigning new judges, as well as prepping for new jury selection and trial proceedings. All of this takes time. You've got to get together a whole new jury pool. You got to go through new filings of motions. Everything has to start kind of from zero, and it does cause delays. Now, in murder cases specifically, a study analyzing appellate court transcripts from 2000 to 2020 found that the national success rate for change of venue motions was about 23.5%. So it succeeds in less than 1 in 4 cases. Overall, courts are generally reluctant to grant venue changes unless there are just really compelling reasons, such as extreme pretrial publicity, which creates a bias, or maybe there have been procedural errors that can be demonstrated. Courts don't like to grant these motions, and usually it doesn't gain you much. They move this to Boise, Idaho. That's 300 miles away. I mean, do you really think people in Idaho didn't know what happened in Moscow? Of course they did. This was 3-inch screamer headlines in the newspaper. It was all over the internet. We live in the electronic age. This was in their state. They knew about it. The only thing it might gain is that you have more people that maybe didn't know or hadn't seen these kids around town, around that county. So maybe you have a better chance of finding jurors that hadn't seen them, noticed them, encountered them in their stores or restaurants or something. But you're certainly not going to find people that hadn't heard about the case, didn't know about the case, didn't have feelings about the case. The decision depends on specific circumstances of the case and the reasons presented for the change. Now, a change of venue is usually based on ideas of they can't find an impartial jury. And that's why I say people are going to be upset about this case anywhere in Idaho. I think they would be upset about this case if it was in El Paso or LA or wherever. This was a national headline case. It's, I think, just a defense tactic to delay. But listen, it takes away one more thing that they can't appeal on if, in fact, he is convicted. So probably a good idea to grant it because it takes away a chance for him to reverse the conviction if, in fact, a conviction is obtained. Coming up, there's such a desire for closure, for justice. We just have that as human beings. And verdicts don't always bring peace to families and friends and loved ones. This message is sponsored by Greenlight. Remember summertime as a kid? The freedom, the boredom, the first taste of independence? Like setting up a lemonade stand or earning your first dollar. Summer's the perfect time to teach kids real-world money skills that they'll use for life. Greenlight is a debit card and money app for families. Parents can send money, manage chores, and track spending. Kids learn to save, invest, and spend wisely, all in a fun, game-like experience. My producer, LaFern, and her son, David, use it and love it. I wish I had Greenlight when my kids got their first allowance. It would have made life so much easier. Greenlight is the easy way to raise financially smart kids. Don't wait to teach your kids real-world money skills. Start your risk-free trial today at greenlight.com/Phil. That's greenlight.com/Phil. greenlight.com/Phil. So in summary, you look for a change of venue if you think you're going to have trouble getting an impartial jury. You can look for it if you think the political climate is just really biased against your client, or if you think the judge can't be fair because they've got a vested interest in it, and if the location of the court is really inconvenient for non-party witnesses, which is not the case here, or if you think that the case was filed in the wrong jurisdiction to begin with. And the factors that influence the decision on the part of the court is if the requesting party can show evidence of prejudice, if they can show that maybe the newspaper, the radio, or whatever have been so biased in one direction or another that there's just not any way somebody can come in with a clean slate in their mind. Or if the severity of the case is so serious, so egregious that people just couldn't possibly come in with a fair and balanced opinion. Or if they would have to take extra precautions if they stayed there because it's so high profile and emotions are running so high that they feel like their client could be in jeopardy. So they got to get them out of there because they think they could actually be at risk for being in that situation. They're also arguing about rulings on details like cameras in the courtroom, media access, sealing or unsealing of sensitive documents. All of that has taken time. Pre-trial motions and other legal challenges have flown like confetti in this case. Kohberger's defense has filed and continues to file complex legal motions. They wanted to dismiss the grand jury indictment, claiming there were procedural errors. They're trying to suppress or challenge evidence, including the use of this kind of commercial genealogy, which, remember, was the cornerstone of the prosecution's evidence against him. That's how they identified him as their suspect. They used something that you could just go pay $99 for, and they identified a cousin. And from the cousin of this contact DNA they found on a snap, they identified relatives that traced back to Kohberger. So it was a very circuitous way to get back around to him. And they're saying, that's not really a chain of evidence type proper standard for identifying somebody. And there's a motion to remove the death penalty from the case, arguing that it's just unconstitutional. Now, many of these motions, as of November of 24, have been denied, but nonetheless, they took a lot of time in the court system, and you have to go through those before you can move on to scheduling things that actually move the case forward on its merits. Understandably, these postponements have been a source of frustration for the victims' families. I can only imagine how these delays have added to their pain and heartache. Because look, they're hurting, and nothing that happened in this court is going to bring back their loved one. But they want accountability. They want justice. And when asked about the pushed back trial date, Madison Mogen's mother, Karen Laramie, answered, "I don't have a lot of comments about that. I would say that the legal system is not about the victims, and I'll leave it at that." Now, earlier I was talking about the ripple effect. When something like this happens, families of the murder victims, they face a wide range of emotional and psychological challenges. These just get worse while waiting and going through a trial. I mentioned in passing before, I want us to understand the impact on everybody involved. Let's look at it from the standpoint of the survivors here, the surviving family members. We look at stress events in our lives, and there are lots of things that are called stressors. It can be getting a divorce, your children going off to school, moving is a big thing, changing jobs, being fired, financial distress. These are all stressors that we deal with in our lives. But number one, sitting atop the list, is the death of a child. And when you break that down into subcategories, the sudden death of a child and the violent sudden death of a child sits atop. That is the number one stressor that a parent can experience in life. The sudden, violent death of a child. The deep loss, of course, there's a grief process that they go through, and it can lead to depression, of course. And it's very difficult to work your way through that. They'll never get over it, they'll just get through it. And it's hard to really turn your attention, your heart to healing when you're still in combat mode. You're still fighting for justice, and you feel like you're fighting to get this person found and then held accountable, and then you feel like, now I'm fighting the system. It seems like the system is more concerned about the defendant's rights than they are the victim's rights. And I hear that from family members all the time. It leads to anger and frustration. And that's, of course, directed at the perpetrator or who they believe to be the perpetrator, but it can also be directed at the legal process. It can be directed at the police, the investigators. There's a feeling of anxiety and stress. And this only gets worse when there are constant disappointments. You think, okay, we've got a trial date. No, we don't. It's been pushed. Well, we got another trial date. No, we don't. It's been pushed. You see this person getting all the headlines. It seems like all of the attention goes to the perpetrator. Their picture is in the newspaper and headlines about them and stories about them. What about the victim? Why isn't anybody running front page headlines about my daughter or my son, talking about what wonderful people they were, what contributors to society they were? Well, because that doesn't sell newspapers the way it does to talk about the evil, to talk about the victim. And that is true. Sometimes the evildoer gets the attention in the headlines, and it seems like the victims get lost, which is why I wanted to take the time here to talk about these four wonderful, energetic, enthusiastic, great-spirited young people. These were wonderful young people with their whole lives stretched ahead of them. We can't forget these young people. There's this sense of helplessness that comes about, like I can't make the system move. You do feel isolated through all of this. And you feel like you're alone in this. And sadly, you're not, because it's very typical for people to feel this way. And when this sense of loss is experienced as a result of such brutal crime, and it's so highly publicized, it's almost like every time there's a headline about this perpetrator, you feel violated again. And every headline, every court delay, every proceeding, it brings it all back as though it happened again yesterday. Every time you turn on the news and you see a picture of this horrible suspect, it brings you back to the night or the morning after where you heard about all this. Every time they start revealing new details about how traumatic the incident was, it's just right in your face all over again. It starts taking a physical toll, not just mental and emotional. It disrupts your sleep. When you don't sleep well, then you get fatigue. When you get stress, fatigue, lack of sleep, all of your resistance to illness is compromised. If you had an illness, your ability to fight it is compromised. And if you didn't, your susceptibility to getting sick is amplified. That's what I mean by ripple effect. It takes its toll. And that's on the family members and friends. It affects so many people. There's such a desire for closure, for justice. We just have that as human beings. And verdicts don't always bring peace to families and friends and loved ones. A guilty verdict doesn't bring back a loved one. Even execution of the perpetrator doesn't do that. But it can help. Coming up, one of the most confounding questions in this case is motive. What on earth would drive this man to do such a thing? You've heard me say it before. Real change starts with real understanding, and that's why I've had Dr. Daniel Amen on my show many times over the years. At Amen Clinics, they do something different. They look at your brain. With nearly 300,000 brain scans from patients in over 155 countries, they take the guesswork out of mental health care. Anxiety, depression, trauma, memory issues. If you're struggling, it's time for answers. Call 866-580-6569 or go to amenclinics.com/Dr. Phil and take the first step. Call 866-580-6569 or go to amenclinics.com/Dr. Phil. We know the prosecution is confident in their evidence against Bryan Kohberger. However, while his legal team, led by Chief Public Defender Ann Taylor, hasn't publicly denied his involvement in the murder, they spent the past year aggressively challenging the case against him. Now, what I've said is they haven't come out and said he did not do this, but they are challenging all of the evidence against him. And a plea, even though it was read into the record by the judge, is not guilty. Now, you're probably thinking, who could do this? What kind of person could stand up and defend a monster that would do such a thing? Well, that's their duty as an attorney. And that's part of our system. Somebody has to do that. Who knows? She may go home every day and feel like she has to take 5 baths after meeting with some of the people that she has to represent just to get the creep off of her. Who knows? But what her job is to make sure they get due process. Doesn't mean that she believes in them, doesn't mean that she endorses anything that a defendant might be accused of doing, but they are entitled to a defense. They are entitled to due process. So let's get into what his defense has had to say about his case so far. And here's what we know. His defense is highlighting his supposed medical conditions. Now, I'm going to tell you that my opinion, it's just my opinion, is that his attorneys have really reached and really stretched here. They filed earlier this month their plans to present evidence of his multiple diagnoses, such as autism spectrum disorder and obsessive compulsive disorder. Documents filed argue that Kohberger's behaviors are highly consistent with autism, but without explanation, others may misinterpret or misidentify Mr. Kohberger's behaviors and cast them in a more sinister light. They also state that due to his diagnoses, executing him would violate the 8th Amendment's prohibition against cruel and unusual punishment. Now, here's the thing. I think what they're alluding to with this autism spectrum disorder is that if people look at their client and he seems to be kind of cold and detached and not behaving in a way that people would expect someone to react and behave, they're saying that they could be misinterpreting that because he doesn't have the ability to react the way others might react. So that could prejudice him. And the OCD, we'll get to that in a minute, but this new filing cites an evaluation by a neuropsychologist who's hired by the defense, who found that Kohberger, quote, continues to exhibit all the core diagnostic features of autism spectrum disorder currently, with significant impact on his daily life. Now, the experts are two women, one who performed his medical evaluation, Dr. Rachel Orr, and there is no publicly available record specifying how many times Dr. Orr has testified in court. However, she is a board-certified neuropsychologist who provides forensic evaluations which suggest she may have experience in legal settings. She owns a neuropsychology practice or organization where she offers neuropsychological assessments for clinical, educational, and legal purposes. The other testimony the defense wants to include comes from a DO, a Dr. Ryan, DFAPA, and from her bio, she says, I'm a general forensic and child and adolescent psychiatrist specializing in suicidal behavior as well as psychiatric emergencies. And goes on to say, as a forensic psychiatrist, I perform civil and criminal psychiatric interviews and evaluations for the judicial system. My areas of forensic interest include medical malpractice and institutional negligence, sexual abuse, and offending mental illness and criminal offending traumatic brain injury, TBI, PTSD, and risk assessment. I have extensive experience with psychiatric evaluations and have been qualified as an expert witness in a wide variety of courts across the United States. Now, to be clear, these conditions are not offered to impact his competency to stand trial. There's been no claim thus far that he's mentally unfit to face the charges against him. Let me be clear. When a trial lawyer goes and hires experts, they're not going to offer those expert reports or those experts as testifying experts unless they're supportive of their theories. I don't know either of these experts, and they seem to be highly educated and seem to be qualified to render opinions. So I don't mean to disparage either of them in terms of their credentials at all. What I will say is that trial lawyers will seek out an expert until they find one that says what they want them to say. If they get an expert that doesn't say what they want them to say, then they will designate them as a consultant, as a non-testifying expert, and then their report, their opinion, is protected. It's lawyer work product. So it can't be discovered by the other side. When they find one that sees things the way they want them to see it, then they'll designate them as a testifying expert. They'll produce their report to the other side, and they'll designate them as a testifying expert in the case. Now you think, well, how is that fair? Well, I'm not saying it's fair, I'm just saying that's the way it works. If they go to Dr. A and say, here's our theory, can you evaluate our client? They might evaluate the client, come back and say, well, he might have some tendencies towards this way, but there's no way that that would contribute to what he's accused of doing. Or they might come back and say, no, I don't see any indication of this diagnosis whatsoever, and even if it did, it wouldn't contribute to what he's accused of doing. Then they'll have to bury that, because they can't put that expert up and have somebody cross-examine them and say, do they have this diagnosis? And if they do, would it contribute to committing the crime? They can't say, nope, doesn't have it. And if you did, it wouldn't contribute to the crime. Then that really hurts their defense. So they can't do that. They have to designate them as a consultant on the case to protect that report so the other side can't get it. And so they'll go find another one. And a lot of times there are experts out there that are defense specialists or plaintiff specialists. And when you dig in, you'll find out that this is a highly credentialed individual that has testified 47 times, all for the defense. Or they've testified 39 times, all for the plaintiff. And they become known in the legal community as someone that testifies for the defense or for the plaintiff. They get a reputation that way, and that's how they get hired. And then when they get on the stand, a good cross-examiner will say, now, how many times have you testified? Well, 48. How many times have you testified for the defense? Well, 48. So isn't it true that you just basically work with the defense and try to give them supporting data for their theories? Well, no, that's not true. I call them as I see them, and I work for the defense because that's who hires me. I started out working for the defense a few times, and I guess word spread, and so that's what happened. But that doesn't mean that I have falsified this data. It's standardized. You can look at it. You can replicate it. I'm sure that you have. But that doesn't mean that I've falsified this data. And then the plaintiff will get up and they'll call their expert and say, how many times have you testified? Well, I've testified 39 times. How many times have you testified for the defense? Well, none. So you always testify for the plaintiff. Well, I'm just saying, I started getting hired by the prosecution, and when I got hired by the prosecution, then I got hired again by the prosecution, and so the defense just didn't want to call me, I guess. I would work for the defense if they called. I just do the test, I do the evaluations, and report what I find. It doesn't influence my findings. How many times have you been hired and they didn't let you testify? Well, none. So you pretty much tell them what they want to hear. Isn't that right, sir? Isn't that right, ma'am? No, that's not right. Blah, blah, blah. So it becomes a war of the testifying experts, and sometimes they tend to cancel each other out. So if you're ever on a jury, you need to listen for those kind of questions to see whether or not you have someone that is a true evaluator or someone that always seems to come down on the side that has hired them for that case versus someone that says, well, no, I'm about 50-50. I've testified for prosecution, I've testified for the defense, and sometimes they don't use my report because they don't like what it says. In the legal arena, they sometimes refer to them as testifying whores that just take the money and say whatever you want. Now, I have no idea regarding these experts for the defense if they've ever testified before, if it's always been for the defense or if it's been for the plaintiff or whatever. Don't know either of these experts, don't have any data as to who they testify for or how. It just appears that they are well credentialed, but I can tell you that you should watch very carefully for how they're cross-examined and who they tend to testify for most of the time. All we know at this point is they seem to be well-trained and well-credentialed, and we'll hear how the cross-examination goes when they're up there. Now, let's assume that they tell it straight and they aren't just for hire, hired guns. How do these symptoms come together? Of course, they vary from person to person, but how do they come together, and how may they impact Bryan Kohberger? Well, if you're on the spectrum, it can vary from all up and down the continuum. They can have flat affect, limited facial expressions. They could show less emotional expression, which can be misread as coldness, lack of empathy, or it can be read as guilt. They oftentimes can have intense eye contact or a piercing stare, or they could be such that they don't engage in eye contact at all. They might avoid it. So they typically don't respond in a socially comfortable way, which is one of the identifying characteristics of being on the spectrum. Now, there are those that are high functioning that you won't see that at all, but if there are those that have the tendency to lock in, they can be misinterpreted as trying to intimidate someone, when that's not at all the case. That's just a characteristic of their spectrum disorder. Now, in Kohberger's case, his defense has argued that traits like his piercing stare and seemingly emotionless demeanor may stem from these conditions. I think if you did an in-depth study, the number of people on the autism spectrum that have committed violent crimes, up to and including murder, would be very, very low. I mean, infinitesimally low. I'm not sure how this serves their case, other than don't misread my client in the way he behaves in court as being cold-blooded or whatever. I don't think it's a very compelling explanation otherwise, unless maybe they're saying because he is on the spectrum and folks on the spectrum don't do this kind of thing. But I just think it's kind of a stretch. Folks on the spectrum do tend to be awkward sometimes and give inappropriate responses, particularly missing social cues that might cause someone to behave in a way that seems off and lead to unfair assumptions about their intentions. In a courtroom or press setting, a person with ASD or OCD might not respond to emotional topics in the expected way. It could cause a jury to misread them. When you talk about OCD, obsessive is intrusive thoughts, compulsive is ritualistic behaviors, and this could seem unusual, especially under stress, and could be perceived as suspicious. His OCD diagnosis directly factors into the defense's case more directly. In court filings, his defense argues that his OCD causes insomnia, leading him to drive or run at night in order to cope. That would be an atypical expression of OCD, in my experience. This ties into the defense's purported alibi that he was out driving in the early morning hours of November 13th, 2022, as he often did, to hike and run and or see the moon and stars. Now, I do have to note that in response to this alibi, prosecutors have asked to introduce weather reports from that night, late November 12th and the early morning hours of the 13th, which show clouds, fog, and below average temperatures for the area, which would make stargazing really tough. It was cold out, cloudy, you couldn't really see the stars. The defense also cites Kohberger's compulsive hand washing and frequent glove use to avoid germs as relevant to his OCD diagnosis. These behaviors, the defense claims, explain actions on his behalf that might otherwise raise suspicion, like when he was found wearing gloves at his home by police. If somebody is truly OCD, they're likely going to have sought treatment for it. They're going to have been diagnosed for it a long time before this. There's going to be evidence of this behavior that people that have been around him, known him, gone to school with him would testify to. So I think they're going to have a steep hill to climb in finding support for this if it's not true. His legal team has stated that he's been diagnosed with dyspraxia, or developmental conditional disorder, DCD. Now, this is a neurological condition that impacts fine motor skills and coordination. His attorneys argue that DCD affects his dexterity and visual motor abilities that would make it difficult for him to physically carry out the crimes in the manner alleged by law enforcement. But it would also make it difficult for him to drive, and probably hard for him to go to college. This tends to have an early onset, so it would be in his record for a long time. He would very likely have a history of this from childhood and have been diagnosed by a neurologist, and all of that would be discoverable. If they open the door to this by claiming this, then the prosecution would be entitled to his medical records, I would think. But with dyspraxia, there are a lot of things that are impacted, like they're often confused and have difficulty planning. I don't think that he would be able to get a driver's license, and they've said his OCD caused him to want to go out and drive around a lot and to be hiking and that sort of thing, which seems to be at odds with his diagnosis of dyspraxia. Those things seem to be at odds. And one of the most confounding questions in this case is motive. What on earth would drive this man to allegedly do such a thing? Why would anyone do such a thing, of course? And prosecutors have yet to formally present this. Several alleged theories have emerged, and these include tying his alleged murder spree to intense fascination with criminology, his alleged potential connection to the victims through social media, and again, alleged feelings of rejection or resentment towards this type of popular and attractive individual he may have associated with the victims. Kaylee's parents shared screenshots of an Instagram account they believe belonged to Kohberger, and this account appeared to follow both Kaylee and Madison. This account user had even allegedly liked several of Madison's posts. And additionally, reports suggest that in late October of 22, an Instagram account believed to belong to Kohberger sent messages to one of the female victims. When she didn't reply, he allegedly followed up with several more messages. However, these actions and the authenticity of that account has not been confirmed. They don't know for sure, they haven't proved, or at least they haven't disclosed proof that this was Kohberger. So for now, the focus remains on concrete evidence the prosecution believes ties Kohberger to the crime, with the expectation that they may reveal more about his potential motive during the trial. It's an interesting theory because, as I said early on, there's an intimacy on the part of the killer when you stab someone versus shooting them. You can shoot them from 10 or 20 feet, for example, but when you stab them, certainly multiple times, you have to be really close to them. There is a theory that these were very attractive young women, and if Kohberger did in fact feel rejected or resentment or overlooked by these young women, that resentment may have led to him taking revenge on them and doing it in a way that was really up close and personal. But at this point, all we can do is speculate based on the evidence presented before us. It's intriguing to note, however, that prior to Kohberger's being charged, when the alleged homicide suspect was still at large, I discussed a potential criminal profile with experts, and we spoke about what's known as the dark triad. Take a listen. This mass exodus from Moscow, because of people not feeling safe there, would allow this killer to leave in plain sight and not stick out as somebody that all of a sudden he's there, then there's this murder, then he's not, and could possibly be long gone and therefore much harder to locate, much harder to find. We don't know. And I want to talk a little bit about what kind of person, what kind of mentality, what kind of maladaptive emotionality it takes to do something like this. You're talking about a real psychopath here. You're talking about someone that lacks empathy. You're talking about someone that's probably very narcissistic. And there's something called the dark triad. And a dark triad is something that kind of goes beyond the diagnostic categories. It's three traits or characteristics that we've identified: psychopathy, narcissism, and Machiavellianism. And these are three characteristics that, when they occur together, it's the perfect storm for evil. It's the perfect storm for people that will kill someone for sport. They will kill someone where they get that feeling, that satiation, that high from doing it. And they can go into a frenzy, which is why they would go to the next bedroom and kill somebody else until they got to the point of exhaustion or fatigue or something scared them away. Now, to be clear, I have never met nor diagnosed Bryan Kohberger. It would be inappropriate for me to render a diagnosis without having seen him, sat with him, done a structured interview, administered appropriate psychometrics, and built a profile that would lead to a diagnosis. What was being discussed there was a hypothetical, a potential profile that I discussed with experts based on the heinous nature of the crime, a bloody quadruple homicide. I explored the concept of the dark triad. The dark triad is a combination of three things that, when occurring together, can really bring about bad results. We're talking about psychopathy, narcissism, and Machiavellianism. Psychopathy is when you just are cold and you feel entitled, you don't have any remorse, no empathy. Narcissism, you feel entitled and special and the rules don't apply to you. Machiavellianism is that dark, dramatic, evil twist and turn to a personality that permits you to do things that just cross the line. Now, before, notably in connection with Ted Bundy, I talked about this, as you will recall. And I interviewed one of Ted Bundy's survivors, Rhonda Stately, whose account was nothing short of chilling. And interestingly, even Bundy's former defense attorney, John Henry Brown, has publicly noted that what are, in his opinion, parallels between Bundy's actions and those of Bryan Kohberger. He noted that both individuals allegedly crossed state lines to commit their crimes in jurisdictions with active death penalty statutes. Bundy from Colorado to Florida, Kohberger from Washington to Idaho. Additionally, Brown pointed out that both were accused of early morning attacks on college students in their residences, entering through back doors while some victims were asleep. While all this is going on, just know the prosecution is not letting up. And we can take a quick look at what new evidence the prosecution has recently admitted into evidence as the trial date looms. They looked at Kohberger's Amazon purchase history records, and it indicates that in March of 22, 8 months prior to the murders, Kohberger purchased a K-bar knife, sheath and sharpener. And you remember, a K-bar knife is believed to have been used in the stabbings, and a K-bar knife sheath was found at the crime scene. A selfie photograph taken by Kohberger at 10:31 on November 13th, just hours after the killing, has been submitted to be shown at trial. Prosecutors argue this image is relevant for submission because of the surviving roommate's description of the intruder as having bushy eyebrows, a feature prominently visible in the photo. If Kohberger is found guilty, this photo of him takes on a haunting and terrifying quality. In it, he's smiling and giving a thumbs up in what appears to be a bathroom selfie. Victim Kaylee Gonsalves' father, Steve, offered his opinion, saying that to his way of thinking, this photo served as a, quote, little trophy to let himself know, hey, I got away with it, close quotes. We'll see if it's later shown during trial. And then there were text messages. In public court documents submitted by Senior Deputy DA Ashley Jennings, the prosecution seeks to admit communications between the surviving roommates in the house from the early morning hours of November 13th, 2022. These messages include attempts to contact the victims and discussions about an unidentified male inside the residence. The texts are listed under the initials DM and BF, which are the initials of surviving roommates Dylan Mortensen and Bethany Funk. Around 4:22 a.m., after unsuccessful attempts to contact their other roommates, the following exchanges took place. DM to BF, no one is answering. DM to BF, I'm really confused right now. BF to DM, yeah, dude, WTF. BF to DM, Xana was wearing all black. DM to BF, I'm freaking out right now. Dylan Mortensen, AKA DM, then described to Bethany Funk, BF, what she was seeing. An unknown individual inside their residence. DM to BF, no, it's like a ski mask almost. BF to DM, STFU. DM to BF, like he had over his forehead, and DM to BF, I'm not kidding, I am so freaked out. BF to DM, so am I. Concerned for their safety, Bethany to Dylan, run. Then it looks like Dylan had more attempts to reach the other roommates. DM to Kaylee, what's going on? DM tries to call Xana's boyfriend Ethan and gets no response. The following morning, Dylan continued her efforts to contact her roommates Kaylee and Madison, who at this point, we now know, were dead. DM to Kaylee at 10:30 a.m., please answer. DM to Madison, are you up? According to court documents, Dylan Mortensen later told investigators that she had been woken up by noises in the home at around 4 a.m. that morning and heard a voice she believed to be Kaylee say, "There's someone here." She also heard what sounded like whimpering coming from Xana's room and a man's voice that she was sure was not Xana's boyfriend Ethan saying, "It's okay. I'm going to help you." Your heart breaks for these young women who were likely overwhelmed with fear and confusion. perhaps frozen, unsure of what to do in such a terrifying moment. As their concern grew over what they were hearing and the well-being of their roommates, it ultimately led to that 911 call when the victims' bodies were discovered the next morning. However, in response to this filing, the defense has pointed to the lapse in time between the panicked text and the 911 call, alleging that this gap raises questions about the roommates' actions and decisions during that time. So, where does this trial stand now? There seem to be updates daily. For one thing, prosecutors have indicated that members of Kohberger's family may be called to testify during the trial. Consequently, they have requested the court to limit his family's attendance during proceedings to prevent them from hearing other testimonies beforehand. Meanwhile, Kohberger's defense team has recently filed in regards to the following: motion to dismiss the bushy eyebrows testimony. The defense aims to exclude this roommate's description of the intruder, deeming it vague, unreliable, and potentially prejudicial. His defense has filed motions to address concerns about potential bias during trial. They've asked the court to ban clothing displaying items of the victims, arguing that it would sway the jury emotionally. They also seek the use of terms like psychopath and sociopath, deeming them prejudicial and unfairly damaging to their client. And with regard to surveillance footage, his defense wants to block about 12 and a half hours of surveillance footage from the night of the murders, calling it overly broad and difficult to review. They're also challenging footage from several local businesses in key locations like the Corner Club and Grub Truck, places where Madison and Kaylee were seen prior to the murders. They're filing to exclude financial records. The defense seeks to exclude Kohberger's Venmo, PayPal, and bank records. They want to block student records. They don't want Kohberger's university records, including his coursework, his emails, and his thesis research involving crime-related questionnaires as part of his thesis. And this is very interesting because he apparently distributed a questionnaire exploring individuals' thoughts and emotions during the act of committing a crime. While the defense sought to block evidence that Kohberger purchased a black balaclava in January 2022, matching the masks described by a surviving roommate. Prosecutors argue the item is crucial to their case and are pushing to include it at trial. So what happens if he's ultimately convicted? As we've discussed, the prosecution has announced its intent to pursue the death penalty. And Kaylee Gonsalves' family has been outspoken in their support of that decision. If Kohberger is convicted and sentenced to death, he could potentially face execution by firing squad. In 2023, Idaho reinstated this method as a backup to the state's ongoing difficulties obtaining the drugs required for lethal injection. While this method isn't likely, it is on the table. We'll certainly continue to follow every development in what has become one of the most disturbing murder cases Idaho has seen in recent memory. In the midst of all the legal twist and media attention, it's important to remember what truly matters. The victims. Kaylee, Madison, Xana, and Ethan. These were 4 young lives that were taken far too soon. Our thoughts remain with their families as they continue on the path towards justice. At sentencing, Kaylee's father addressed the court, looking Kohberger in the eyes and saying, "You picked the wrong families." Kaylee's sister, Olivia, said she memorized her impact statement so she wouldn't look away while confronting him. She said, "You're a pathetic, delusional loser. When it comes to these victim statements, when someone walks into the courtroom and stares down a person who took someone away that they love, who destroyed their family, this isn't about revenge. It's about standing up to who they see, who they feel is a predator and a monster. It's about reclaiming their power. It's about making a statement to that person that we are not afraid of you, we don't run from you, we don't hide from you. We stand up, look you in the eye, and let you know you are held to account. This is a psychological purpose. This is something they need to do where they find this to be highly cathartic. It allows survivors to give a voice to the pain, the anger, the confusion, and give a voice to the one that is not there to speak. It humanizes that victim. It humanizes them and the one that is lost. And it happens in a space that otherwise reduces people to just evidence, procedure, all of the coldness that happens in trial. It humanizes them. And it helps the court understand the crime. It's about helping the victim's loved ones make meaning out of the senseless loss that they've had. It gives meaning to the suffering. They reconstruct the narrative, and the person tells the story in their own words. It's not filtered through lawyers, detectives, or headlines. And these statements can be raw, sometimes furious, because grief is just non-linear. They're trying to compress loss into a few paragraphs. And this sister stood up and memorized her entire statement just so she could keep eye contact with the man that she calls a monster. That wasn't for him. It wasn't to make him see the error of his ways. It wasn't to make him feel guilty. He is guilty. He'll never breathe another breath of fresh air. This was for her. Olivia delivered a 10-minute victim impact statement during which she called him pathetic, a sociopath, psychopath, murderer. She said, "The truth is, you're as dumb as they come, stupid, clumsy, slow, sloppy, weak, and dirty." She said that at one point before ending her statement. Olivia gave Kohberger a truth she said he would hate the most. She said, "You want the truth? Here's the one you'll hate the most. If you hadn't attacked them in their sleep in the middle of the night like a pedophile, Kaylee would have kicked your effing ass." That's an act of psychological defiance, and it can be part of what restores agency to her. She's speaking for her sister. And Kaylee's father said, and I quote, "You picked the wrong families," making a declaration, an identity. His daughter's life, her memory would not be reduced to headlines or forgotten. These statements, they were from the heart, from passion, from pain, but also from power. And they're statements that will stay with them. It's one thing to look at a crime scene photograph. It's another to hear a mother describe a bedroom that will never be slept in again. Trauma recovery. Witness is part of validation. It's part of overcoming that trauma, taking your power back. It tells the survivor, you were heard, your pain is real, this matters. And it takes courage. These aren't speeches. These are declarations. These are reclamations. Judge Stephen Hippler called Kohberger a faceless coward who carried out a targeted, premeditated slaughter of 4 innocent students while they slept. His words echoed what so many in the courtroom were feeling, that this wasn't just a tragedy, but an act of calculated evil. Following the sentencing, law enforcement said the community could now begin to heal. But one enormous question remains. Why? Kohberger has offered no motive, but according to investigators, they still don't know why he chose those specific victims, or if they were targeted individually or at random. Now that the gag order has been lifted, family members and surviving roommates have begun to speak publicly for the first time. Still, much of the case file remains sealed, including full autopsy reports, digital forensics, and Kohberger's communications leading up to the attack. Thank you for listening. I'm Dr. Phil.